Can you hear us?
Hello, hello.
Hey, honey, I can hear you.
Okay, thank you.
Hey, okay.
right.
Hey.
Fabio, what are you doing? You're muted. I can't hear you, Fabio. Hold on.
He's messing with stuff.
Can you hear me now? Oh, now.
Talk louder.
Hello.
Act like a Texan and talk louder.
Hello.
What?
Okay, mute yourself.
Can you hear me? Is it really clear and everything?
Yes,
coming?
it's really clear.
Okay,
Yes. Now mute yourself.
good. Okay. What are you trying to say? Shut up?
Yeah.
How do you do that? Oh,
Are you trying to tell him to shut up?
yeah, mute myself.
You ready with anybody? Your Honor,
Yes, ma'am.
it'll be just 3 minutes.
3 minutes?
Yes, sir.
Well, I'll tell you what, if the prosecutors are ready, I think, Mr. Woods, I believe, from this morning.
Yes, sir.
He and his attorney are here, so we can go ahead and they're all here. We'll go ahead and bring them in while you are waiting.
Okay.
All right. All right, Mr. Woods, come on up. All right, you're Mr. Allen?
I am.
All right. Alfredo, can you see and hear me okay?
Yes, sir, I can. Can you hear me?
Yes, I'll tell you
Okay.
what, and I'm not set up to, let's see. Carlos, just unplug that computer and put it over here in front of Mr. Woods so that Mr. Woods and Mr. Allen can see the prosecutor. Yeah, just stick it right there on those podiums, right between those two gentlemen. That way, there you go. Excellent. And that way they can see Alfredo. Do you see Mr. Hernandez there? in the lower right.
No, okay. Oh, there it is. There it is.
Hey, Carlos, bring that laptop to, or if you'll right click on top of Alfredo's picture, you can pin that. Just right click on top of Alfredo and it'll say pin. If you'll pin that, it'll make it larger. All right, there we go. Excellent. All right, court calls, for the record, calls number CR 24-00010, State versus La Jasmine Marquette Woods, and Mr. Woods is set for pretrial today. Mr. Allen, have you filed any contested pretrial motions or any motions that need to have some type of hearing?
I have not at this point, Your Honor. A couple of weeks ago, I spoke with Ms. Curran, and advised her that we run a retrieve all of the discovery. Says she's gonna remake that available to us. At this point, we still do not have that, Your Honor. But
What is it that you're missing specifically?
well, I believe the lab reports and any other reports that are affiliated with the stop and the arrest. She did forward over the police reports, but we don't have any other reports other than that.
Mr. Hernandez, were you able to hear Mr. Allen?
I was, Your Honor. I've actually been checking through the events on the file to see if, or to check to see what date that request may have been submitted. It appears, just for clarification, Your Honor, that discovery was sent to the portal back on March 7th. However, I do not see any information regarding those the lab reports. I will note that initially, I believe this case was being considered for federal charges, and that may have been the hiccup in finding out who ultimately would be making the request on getting the alleged substances tested.
Okay, so you don't see any lab report in your discovery at this time, is what you're saying?
That is correct. I do not.
Okay, but you don't know if they exist or not.
I do not know that, Your Honor.
Okay, but all other discovery, that being the arrest report, any other reports related to that, offense reports, those are available to Mr. Allen in the portal link. Is that what you're saying? The discovery?
Well,
link?
they are made available. They have been made available, but he has not signed up to access that information through the link. I believe there's some type of sign up that has to happen for him to be authorized to access those reports. And to date, he has not done that.
You're aware of that, Mr. Allen?
I'm aware of that, Your Honor, and I believe our office signed up for that last month or attempted to sign up for it.
Okay, so.
Yeah, as of today, we don't see that any attempt has been made, Your Honor. That's just the information that I have.
All right, this is what I'm gonna do. I'm gonna reset Mr. Woods for an additional pretrial hearing. Do you have your calendar available, Mr. Allen?
I do, Your Honor.
All right, I'm gonna set this for an additional pretrial hearing on May 2nd. And so what I want you to do, Mr. Allen, is when you leave here, I want you to go over to the DA's office, which is 2 blocks south of here, and meet with one of the legal assistants.
Okay.
And make sure that they have your correct credentials to get into the online discovery portal before you leave. So
Okay.
you should be able to hop on your phone, get into it. That way, before you leave, you know you have it.
Okay.
And maybe there's some issues with credentials or something, I'm not sure, but I want you to go ahead and do that today. Let me see, will you give me a notice of appearance form? All right. All right, Mr. Allen, if you'll sign here where it says defense attorney and have your client sign, and then I will keep the white copy and your client will get the yellow copy. Coming back on May 2nd at 9 a.m. And so, Mr. Allen, any contested pretrial motions, motion to quash, motion to suppress, any of those motions that are going to need a hearing will have to be filed 7 days prior to that May 2nd date. And then on a pretrial date, once you get them filed, then we'll set them for a hearing. If you file a motion to suppress or something, and you may not be able to if you don't have all of the reports back. So once you check the discovery, if you know that you need one,
Right.
file it, and then we'll get it scheduled later.
Okay, all right. Thank
All
you.
right. If there's nothing further, then Mr. Woods, you're free to go.
All right, thank you.
All right, Ms. Abraham, we are ready for the jail court when y'all are ready.
All right, Your Honor, Mr. Millsagel is ready on Mr. Butler.
All right, good afternoon, Mr. Millsagel. How are you, sir?
Good afternoon, Judge. How are you?
Doing great. Let me flip back here to your client.
Your Honor, if I may just interject,
Yes, sir, go ahead.
I think we were still missing the stipulation of facts, and Miss Curry was going to be preparing that. At least I wasn't advised to take care of it over the lunch hour. She's been in a meeting. I don't know if she's had a chance to do that. Do you have that in the packet? It was going to get emailed separately.
The packet that was provided to me does not contain a stipulation of evidence.
So we will need to get on
Judge,
that and get that.
we do have it right here.
You do have it, Mr.
Yes.
Millsagel? Okay, good. Then in just a moment.
Oh, great.
Excellent. And then in a moment after we get through the plea, I'll ask you to recite that into the record for me.
Yes, Your Honor.
All right, the court calls cause number CR 22-62, CR 24-45, State of Texas versus Corey James Butler. Mr. Butler, sir, if you'll raise your right hand, I'm going to place you under oath. Mr. Butler, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, thank you. Put your hand down. Is your name Corey James Butler?
Yes, sir.
And Mr. Butler, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Matt Millsagel. Are you pleased with Mr. Millsagel's representation?
Absolutely.
Do you feel like you've had enough time to discuss the cases with him and have all of your legal questions answered?
Yes, sir.
Is there anything about your cases or the paperwork that you signed today regarding your plea that you do not understand?
No, sir.
All right, thank you. And Mr. Millsagel, do you believe Mr. Butler to be competent today to enter into an agreement?
Yes, Your Honor.
And you've explained to him his rights concerning these cases, correct?
I have, Your Honor.
And do you believe that Mr. Butler is entering into these agreements intentionally, knowingly, and voluntarily?
Yes, Your Honor.
All right, Mr. Butler, in cause number CR 24-45, you are charged by indictment with the offense of escape while arrested or confined for a felony. That is a third-degree felony, which does carry a range of punishment of not less than 2 years or more than 10 years confinement in TDC, and also a possible fine not to exceed $10,000. I see that the plea agreement in this case is that upon your plea of guilty, the state's recommending to the court that the court convict you of that offense, assess your punishment at 6 years confinement in TDC, along with a $1,000 fine. And as part of the agreement, the state's agreeing to dismiss CR 22-62, which is a possession of controlled substance between 1 gram and 4 grams, a third-degree felony. In addition, you would have court costs of $290. You would also have to pay reimbursement fees of $15, and you would receive 251 days credit towards your sentence for the time that you've already spent in jail on this case. Is that your understanding of the plea agreement, Mr. Butler?
Yes, Your Honor.
All right. So, Mr. Butler, understanding the plea agreement, understanding the range of punishment, How do you plead to escape while arrested or confined for a felony, a third-degree felony?
Guilty.
Are you pleading guilty to that crime because you are in fact guilty of committing that crime?
Yes, sir.
Has anybody threatened, forced, or pressured you to plead guilty today?
No, sir.
All right, the court does accept the defendant's plea of guilt. Mr. Millslagle, any objection to the stipulation of evidence?
No objection, Your Honor.
All right, the stipulation is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor, thank you.
Anything further from the defense?
No, Your Honor, thank you.
All right, and Mr. Millslagle, since you have the stipulation of evidence, if you wouldn't mind, just read that into the record, keeping in mind that my court reporter is going to type down what you say, so don't read too fast.
Yes, Your Honor. I have before me the stipulation of evidence. Comes now the state of Texas together with the defendant and his or her counsel and stipulate to this honorable court that the following facts are true and correct and could be proven during a trial of this matter beyond reasonable doubt. My name is Corey Butler. I am the defendant in this case. On April 21st, 2022, I was arrested by Constable Tommy Monk and Grand Saline Police Department Officer Mackenzie Chandler. I was placed in a police vehicle. I escaped from the vehicle by crawling through the prisoner window and opening the driver's door. It is signed by the state, myself, and Mr. Butler will be signing it right now.
Thank you, Mr. Millslagle. All right, then based on the evidence presented to the court finds that there is sufficient evidence to convict the defendant of this offense. The state follows the plea agreement between the state and the defense. The court convicts Corey James Butler of escape while arrested or confined, a third-degree felony, assesses his punishment pursuant to the plea agreement at 6 years confinement in the Texas Department of Criminal Justice Institutional Division, orders Mr. Butler to pay a $1,000 fine, $290 in court cost, $15 in reimbursement fees. And the court also dismisses cause number CR 2262 based on the state's motion to dismiss and their agreement. Mr. Butler is hereby awarded 251 days credit towards his sentence for the time that he's already spent in jail on this cause. Mr. Butler, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. I'm going to have you step over with the deputy to be fingerprinted. Good luck to you, sir.
Thank you. Judge, that's all I have, may be excused.
Yes, thank you, Mr. Millslagle. Appreciate you.
Thank you, Judge.
All right, Mr. Schmidt, who would you like first?
Harold Holmes.
All right, Mr. Holmes, if you'll come up, CR 2455, CR 2456, CR 2457, State versus Gerald Alexander Holmes for arraignment. Go ahead, Mr. Schmidt.
Judge, pertaining to arraignment on those three cause numbers, we received copies of the indictment. His name is spelled correctly, understand the charges against him. We've waived formal reading, enter a plea of not guilty as to all charges, asked for pretrial setting on those.
All right, the court finds that Mr. Holmes has waived the formal requirements of arraignment. Court does enter his plea of not guilty into the record for each charge. The court will set Mr. Holmes now for a pretrial hearing. You want that May 28th date, Mr. Schmidt?
Do you have a little bit later? I think we're piling up on May 20th.
We've got the next Tuesday that would be available would be June 18th.
June 18th sounds fine.
All right, court sets Mr. Holmes for pretrial hearing June 18th. That will be at 1:30, unless Mr. Holmes makes bail. If he posts bail, then his hearings will be at 9 a.m. on that same day.
Judge, we also have a writ report that needs to be taken up and that was filed previously. It is not on these three indicted cases, it's on an unindicted case.
Okay. All right, and is that regarding a charge of aggravated sexual assault of a child?
It is, Judge.
Okay, do you want to call your client as a witness?
Judge, I would make argument first. Basically, it's a statutory 17-151. Mr. Holmes remains unindicted on those charges. He was arrested well over 90 days ago and has been in continuous custody. If the court requires testimony on that matter, We can, I don't think that those facts are in dispute.
State, do you want to respond?
Your Honor, if Mr. Schmidt has a case number, or information that, because it's certainly not listed on the docket.
It's a written number on the very last, on a separate docket.
It's a written number WR 24-00010 should be on the
How
last.
do you see it? Yes, sir. Thank you very much. And I guess if in fact the facts as stated by Mr. Schmidt are true, that it's beyond the 90 days, Your Honor, it would be statutory. We wouldn't take a position on requesting any additional testimony.
Okay. All right, then the court finds that Mr. Gerald Alexander Holmes in written number WR 24-00010 on the charge of aggravated sexual assault of a child has not been timely indicted pursuant to Article 17-151. Court finds that Mr. Holmes therefore is entitled to be released on either a personal bond or a reduced bail in the amount that he can make. Mr. Schmidt, I would like some testimony regarding whether or not he has the financial ability, since the court has the ability to either grant a personal bond or reduce it to such an amount that he can make.
Yes, sir, I certainly will.
All right, Mr. Holmes, if you will, you're going to be called for the purposes of your bail today. If you'll raise your right hand, your other hand. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Sir.
All right, you put your hand down. Speak up loudly and clearly for me. I know that you're standing next to Mr. Schmidt. He's going to be able to hear you, but I need to hear what you have to say. My court reporter has to hear what you have to say to write down, okay? Go ahead, Mr. Schmidt.
Your name is Gerald Holmes, correct? Now, you heard the court state that you are unindicted and been in custody over 90 days. Now, over the pendency of 90 days, you have made through your mother and through myself attempts to postpone on the charge that relates to this writ, correct? Yes. And you've had conversations with bondsmen through your mother, and ultimately you were unable to post the bond as set, correct? Yes. In addition to that, your parents were hoping to come up with some funds in the event the bond was lowered, but they were unable to do that as well. Yeah. Now, do you have any of your own property or funds in a bank account, any sort of assets that you can sell to make any sort of bond on this case? Is that a no? Yeah. And you have previously filled out an affidavit of indigency with this court, correct? Yeah. And that affidavit of indigency seeking court-appointed counsel, was that application true and correct? And were there any assets listed on that affidavit that you could use to satisfy a reduced bond? What were those assets?
And,
No,
Mr.
you
Schmidt,
have any assets.
and I can't hear what he's saying at all.
Okay. So your testimony is you have no assets, no funds, no money in which to post a bond, even if it were reduced. Are you asking the court to grant you a personal recognizance bond on the case that is pertaining to the writ? Say again? Yes. Thank you. I'll pass the witness.
Mr. Hernandez, any questions?
Yes, Your Honor. Mr. Holmes, what is the bond currently set at? Do you know?
100,000.
100,000? Okay. And what attempts, I mean, your attorney mentioned that your folks had tried and he had tried. What attempts do you know were made to post that bond?
Title bonds or what is it? Title loans,
I'm sorry?
title loans, but we don't have really nothing.
Okay. And you own no property whatsoever?
No.
You don't own a car?
No.
You don't have any bank accounts?
No.
Where were you living prior to being arrested, sir?
Parents' house?
Parents' house?
Yes.
Do you have any personal property that belongs to you there at your parents' house?
No.
So everything they have there that's yours is actually theirs. You have no ownership interest in any of that.
Yes.
That's correct. Is that what you're saying?
Yes.
Your Honor, I pass the witness.
Mr. Schmidt, anything further?
No, just to clear up, you said title loans. Are you saying that your mother attempted to get a title loan on her property to post your bond?
Yeah.
And those attempts failed, is that correct?
Yes, because they wouldn't approve.
They wouldn't approve the loan. All right, pass the witness.
Mr. Hernandez, any questions, any further questions of Mr. Holmes?
No, Your Honor.
All right. All right, then, based on the evidence presented to the court today, the court finds that Mr. Holmes does not have any assets or personal property in which to secure funding for any type of reduced bail. Court finds that he remains unindicted pursuant to Article 17-151, and the court will reduce Mr. Holmes' bail to $100,000 as a personal bond.
Thank you, Judge.
You're welcome. And Mr. Schmidt, after we're done with Mr. Holmes, we can go ahead and bring up, I'm not sure who you had planned next, but our Spanish interpreter is here. So I'd like to go ahead and get her going on Mr. Whoever we got at 2 o'clock.
Gonna be Garcia. Yeah, we need
Yeah, Mr. Garcia, is it Fuentes?
Judge, I don't think currently we're set up, unfortunately, to facilitate a translator. In addition, he's not in the jail at this point, or not in this room.
What's do we have the laptop out there to do that, or
No, sir.
No, Your Honor.
do you need us to bring one?
We
Do
can
you
come.
Do you mean have someone bring it out to you?
Or we could do it live.
What's the hearing's going to be a pre-trial? Do you have any pre-trial announcements?
We have no contested pretrial at this time as for a docket call, sorry.
Okay, we'll just do it simultaneous then with Ms.
Okay.
All right, so let me know as soon as he gets in there. I'll send her a message. So as soon as he gets in, and if we're not in the hearing, let's get him teed up.
Yes, sir.
I'm gonna send her a message.
It's tucked in a weird place.
He's here, Your Honor.
Oh, okay, well, let me delete this message I just sent.
Right.
Hable duro porque no lo oigan ellos.
All right, good afternoon, Ms. Beal.
Good afternoon, Judge.
We're gonna do things a little different this afternoon. We don't have a laptop set up for the simultaneous translation in another channel. So it's gonna be a very short hearing, so we're just gonna do it consecutive. I'll make sure that myself and Mr. Schmidt will make sure that we give you time to do what you need to do. Court's going to note for the record that Ms. Beal has already made an appearance in this court today, and she's already been placed under oath to translate to the best of her skill and judgment. So what I want to do right now, Ms. Beal, is I want you to go ahead and introduce yourself to this is Kevin Jose Garcia Fuentes. Go ahead and introduce yourself and let him know that you're going to be interpreting, see if he has any questions before we begin. And then whenever you come back to me, we'll get started.
Very well. Buenas tardes, señor García. Yo soy Holly Beal, intérprete oficial del tribunal. Quiero preguntarle, ¿me está oyendo y entendiendo bien? Ok, muy bien. Le voy a pedir cada vez que usted responda que hable bien fuerte para que lo capte el micrófono, ¿de acuerdo?
Ok.
Ok, muy bien. Por último, vamos a ir turnando. Aunque usted entienda la pregunta en inglés, hay que esperar. Yo interpreto al español. De igual forma, yo espero a usted hasta que termine de hablar para interpretar al inglés, ¿de acuerdo?
De acuerdo.
Muy bien. Okay, thank you, Judge. We are hearing and understanding each other. We're ready to proceed.
Thank you, Ms. Bill. All right, this is cause number CR 15-364, State of Texas versus Kevin Jose Garcia Fuentes.
Estamos en acta. Esta es la causa CR 364, Fiscalía de Texas contra Kevin Jose Garcia Fuentes.
Mr. Schmidt, we're here on pre-trial today. Do you have any pre-trial motions?
La pregunta para el abogado. Abogado Schmidt, estamos aquí para una audiencia previa al juicio. ¿Hay algún pedimento que usted quisiera promover?
Judge, at this time, we don't have any contested pretrial motions.
Su señoría, para este momento no tenemos ningún pedimento que se tenga que resolver antes del juicio donde haya alguna controversia.
We'd ask that the matter be set for a docket call.
Pedimos que el asunto, que al asunto se le dé una audiencia anterior al juicio.
In the interim, Judge, I will have to bring my interpreter to the jail to meet with Mr. Garcia Funes. to
Y
go-
mientras,
Sorry, go ahead.
mientras tanto, voy a necesitar llevar a mi intérprete a la cárcel para poder reunirme con el señor García Fuentes.
At which time I'll explain to him negotiations with the state.
Y en ese momento yo le puedo explicar las negociaciones que ha habido con la fiscalía.
So we'd ask for that May 28th date, I believe.
Así que creo que la fecha disponible sería el 28 de mayo, si podemos tener esa cita también.
All right, the court sets the defendant for docket call on May 28th at 1:30. I'm sorry, I'm sorry, Holly, let's do 2 o'clock.
Muy bien, voy a fijar la siguiente audiencia para el acusado para anuncios previos al juicio para el día 28 de mayo a las 2 de la tarde.
Mr. Garcia Fuentes, any questions?
Señor García Fuentes, ¿tiene usted alguna duda?
No.
No.
All right, then we're adjourned in this case.
Es todo entonces por este caso. May I be excused, Your Honor?
Yes, thank you, Ms. Bill. Holly, if you're gonna be my designated interpreter, you just let me know.
Okay, sounds good.
We'll send you a gift basket, we'll send you a new chair, new headset, whatever you want, so.
I love it. Sign
All
me
right.
up. All right, thanks.
Good to see
Bye.
you. All right, Mr. Schmidt, do you have anyone else or do you need some time?
I'm ready, Judge. Let me get my list organized real quick. Daniel West. Mr. West, come on down.
All right, court calls, cause number CR 23-00081, State versus Daniel Keith West. Hearing on the motion to adjudicate, motion to revoke. Go ahead, Mr. Schmidt.
Judge, at this point in time, we're not ready to proceed, obviously. We're still negotiating with the state. We'd ask that it be set on the contested docket date.
All right, we can set it, the next contested would be in 2 weeks on April 30th. Do you want that date?
Yes, sir.
All right, court sets Mr. West for contested hearing on Tuesday, April 30th at 1:30.
David Dixon.
All right, court calls, cause numbers CR 23-177, CR 23-178. State of Texas versus David Paul Dixon. Docket call in each case. Go ahead, Mr. Schmidt.
Judge, at this point in time, we're going to announce ready for trial on both causes. I would give the court the caveat that although I know it's the court's policy not to accept plea offers after the date of announcement of trial, we're having, for whatever reason, we're having a glitch in communication on Mr. Dixon. We hope to resolve it, but at this point, rather than writing a docket call, I would ask that he be set for jury selection. I'll meet with Mr. Hernandez and perhaps bring him back for a plea sooner rather than later.
Okay. All right, the court will set Mr. Dixon for jury selection beginning Monday, May 6th.
I like it. It's a good answer, so. Tyler, Germany.
All right, Mr. Germany, this is cause number CR 18-203, State versus Tyler Young, Germany. Motion to revoke. Go ahead, Mr. Schmidt.
Because we're not ready to proceed at this point, we'd ask they be set on that contested docket.
All right, court sets Mr. Germany for contested hearing on Tuesday, April 30th at 1:30.
Looks like, yes. He's gonna be answer one. Oh, this is done then. Oh, you're talking about, who are you back? Come on. Yeah, choose. Dustin Howard. Mr. Howard, come on down.
Court call CR 23-218, State versus Dustin Blake Howard, arraignment. I believe that we have Mr. Howard on a bench warrant from TDC. Is that correct?
That is correct, Judge. We're ready to proceed on arraignment.
Go ahead.
We received a copy of the indictments, name spelled correctly, understands the charge, will waive formal reading and or plea of not guilty, ask for a pretrial setting.
All right, court finds that Mr. Howard has waived the formal requirements of arraignment. The court enters his plea of not guilty into the record, sets Mr. Howard for pretrial hearing on Tuesday, May 28th at 1:30.
Brian Lunsford.
Brian Lee Lunsford, CR 24-6, pretrial burglary of habitation. Go ahead, Mr. Schmidt.
Judge, we don't have any contested pretrial at this time. We'd ask the court to set Mr. Lunsford for a plea the next available. On the 30th, if the court would entertain us on that date, that would be great.
Yeah, I'm sure we can probably squeeze it in on the 30th. All right, court sets Mr. Lunsford for plea on April 30th at 1:30. Is he gonna be pleading to probation or time?
Time, sir.
Time, all right, so we'll keep it at 1:30 then.
Mr. Mackin.
CR 24-25, CR 24-26, State versus Andrew Casey Mackin for arraignment. Go ahead, Mr. Schmidt.
Judge, we've received indictments. His name is correctly. Understands the charges. We waive formal reading and a plea of not guilty. Both charges asked for a pretrial setting.
All right, court finds that Mr. Mackin has waived the formal requirements of arraignment. Court enters his plea of not guilty into the record in each case, sets this matter for pretrial hearing on Tuesday, May 28th at 1:30.
Donnie Main, Donnie Main.
Ronnie Joe Main, CR 23-326, docket call. Go ahead, Mr. Schmidt.
Judge, we're working with the state still. It asked for an additional docket call setting on Mr. Main.
All right, court sets Mr. Main for an additional docket call. You want that on the 28th as well, or do you want something sooner?
28th would be fine, Judge.
All right, court sets Mr. Main for docket call May 28th at 1:30.
You got it. Cody McCoy,
Cody Lee McCoy, CR 23-111 and 112, docket call. Go ahead, Mr. Smith.
Judge, at this point in time, we didn't announce ready for trial on Mr. McCoy's cases.
All right, has the state made any offers to the defendant that he's rejecting today?
At this point, they made an offer of 4 TDC, and he is rejecting those offers.
All right, and Mr. McCoy understands the court's policy that it may not accept a plea agreement after today, even if the state offers 3 years or 2 years or anything less.
He understands.
All right, court will place Mr. McCoy on the jury selection docket beginning Monday, May 6th. In each case.
I won't be there today. Okay, Friday. All right, I'll let him know Friday. Mr. McDonald.
Jason Wayne McDonald, CR 23-151, arraignment. We also have Mr. McDonald on bench one from TDC, correct?
That's my understanding, yes.
Okay.
No, I'm done with my time.
Yeah.
Yes, sir. And they raised my bond on my misdemeanor and I was bonded out to the,
We'll get that taken care of. But you're out of TDC.
yes, sir.
So you had a Van Zandt County hold, and they just brought you here.
Yes, sir.
So we're good.
Okay, go ahead, Mr. Schmidt.
As far as his arraignment is concerned, we'll waive that. His name's spelled correctly, understand the charges, enter a plea of not guilty. As for that pretrial date, May 28th, I guess.
All right, court finds that Mr. McDonald has waived the formal requirements of arraignment. Court enters his plea of not guilty into the record and sets him for pretrial hearing May 28th.
Is there any way we can check to see if the affidavit?
I'll bet you. Bet you both. Yes, sir. Money, huh? Bill. Come on down, Mr. Mills.
Jeffrey Alden Mills, CR 21-229, arraignment. Go ahead, Mr. Schmidt.
That's correct, Judge. Same announcement, we received a copy of the indictment. He understands the charges, his name spelled correctly, waive reading, enter a plea of not guilty. Ask for pretrial date.
All right, court finds that Mr. Mills has waived the formal requirements of arraignment. Court enters his plea of not guilty into the record, sets this matter for pretrial hearing on May 28th.
David Pesnell,
David John Pesnell, CR 21-183, motion to revoke. Go ahead, Mr. Schmidt.
Judge, we're not ready to proceed. We'll ask you to be set on the contested document.
All right, court sets Mr. Pesnell for contested hearing on April 30th at 1:30.
Hey, Jerry.
Gerald Wayne Powell, CR 21-235. I believe we're on status for the defense expert report. Is that what we're on, Mr. Schmidt?
That is what we're on, Judge. I'm pleased to announce we can stop doing that. We received the report back from the defense expert. I have been in communication with Ms. Curry about the results of those reports. At this point in time, I think it would be probably best for everyone if we set him for a pretrial, contested pretrial setting. I don't anticipate that we will have one. However, I do have, I have a couple of pretrial motions that have been pending for quite some time. I believe that me and Ms. Curry will discuss this more in the immediate future. and we're likely to come to a resolution. But ultimately, some of the statutory procedural requirements based on our defense I need to go back and review those prior to moving forward. But either way, if we can get a pretrial setting, then we could probably get it all in a nice, neat little package.
You said it needs to be on an evidentiary day so that testimony or argument can be had.
I think that there's a possibility that that would be necessary, so we might as well. And hopefully if we can get past that, then we can. If we can't, then we'll be set.
Is the April 30th date sufficient?
I imagine so. I'd ask for a date simply because I'm packed up on that date already. And I need to
Next
focus
next
on
one would
the-
be on a Thursday, May 30th.
Okay, we can live with that. May 30th should be fine.
All right, court sets Mr. Powell for pretrial hearing. Well, we'll call it evidentiary hearing on May 30th at 1:30.
Mr. Whitten.
Michael Joseph Witten, CR 24-9 for pretrial. Go ahead, Mr. Schmidt.
Judge, announcements, no contested pretrial at this point, ask for a docket call setting.
All right, court finds there being no contested pretrial motion, sets us for docket call hearing on Tuesday, May 28th, 1:30.
Zachary Wooten.
Oh, written. Oh, I see it there. All right, this is cause number CR 2255, CR 2256, State versus Zachary Wooten. Motion to revoke. Go ahead, Mr. Schmidt.
Sorry, Judge. I gotta turn you up with some air conditioner or something came on. It's pretty dang loud. What's the? There's. Okay. Could you repeat yourself, sir?
But yeah, I was just announcing the case for Mr. Wooten on motion, his motions to revoke. I've called the case, so yeah, what's your announcement?
Judge, at this point in time, I think there's some procedural questions that we have about some of the underlying counts on the motion, which have Mr. Wooten appearing in county court at law. Simultaneously, I think what I'm asking for is additional setting on this prior to a contested, see if we can't get all that stuff organized. And I believe you have Mr. Jim Wheeler. He has Mr. Wheeler on in the county court of law, so. Okay.
So he has these two charges, CR 2255 and 56, and you're saying there's another misdemeanor charge that Mr. Wheeler represents him on downstairs?
That's correct. It's my understanding that those form the basis for at least one or two of the counts alleged in the state's motion to adjudicate.
Okay, so you're just asking time to get with Mr. Wheeler so y'all can try to
Yes.
do some kind of complete
Correct.
wrap up. All right, you think April 30th is enough, 2 weeks?
Definitely try.
Okay. All right, court sets Mr. Wooten for contested hearing on April 30th at 1:30.
Well, if I got You for bond, for bond. What's your name?
He's mine.
It's yours.
Mine.
You want me to take him from you? I'll take him, I might as well. It's all right, okay.
No, but I'll pump you.
Marshall, oh, you got just one?
Yeah.
Well, why don't you take care of yours just one and I'll talk to you next part of it.
Like Larry Bird, never hand me the ball because I will not give it back. No, I was at the courthouse handling other business, so thank you. Good afternoon, Your Honor.
Good afternoon, Mr. Spriggs. Come on up. This is
Hey, come
cause
on.
number CR 21-371 State versus Casey Lynn Spriggs. Go ahead, Mr. Ashmore.
All right, Judge. Good afternoon, Mr. Hernandez. Good afternoon. Judge, first I need to address that there is a lot of compliance by the district attorney's office with discovery requests. And unfortunately, those discovery requests have led to yet another discovery request. Last week, I filed a motion disclosing to the district attorney's office, and I called Mr. Hartwell, who informed me he could not be here today. We did not have a chance to follow up and reconnect with his colleagues. That the 9 videos that were previously produced have, one, we appreciate them. Mr. Spriggs and I have had a chance to review them, and in those videos is a disclosure that there might yet be another video or set of videos from when Mr. Spriggs was picked up by a Dallas law enforcement agency and taken to Parkland. He specifically makes a statement or a reference to that in these 9 videos that we just got. I've made a request to the DA's office. I spoke to Mr. Hartwell about it. We just didn't have a chance to reconnect before today. I know he's out. Mr. Hernandez, if this is surprise to you, welcome to the party. Sorry about that. That wasn't intentional. And so I'm going to ask for some time for the state to investigate whether those exist and can be found. And then we have some other pretrial motions. However, the court has always taken the position that if we're not quite ripe for a real pretrial and an evidentiary pretrial, we should clear the decks on all the discovery issues before we go into the motion to suppress or anything else that may be on file. And that's really the only, besides our ex parte motion for expert assistance, that doesn't require Mr. Hernandez's or Mr. Spriggs for that matter. I think you judge that expert is standing by telephonically, or she can even get on the Zoom if necessary. However, again, that's an ex parte request, and we would prefer, at least if there's going to be some disclosure from that expert to the court, that be at least initially ex parte. So that's a whole lot of saying we're not quite ready for a pretrial hearing. I apologize. I did not know that the 9 new videos would lead to the possibility of discovering even more videos, but it has. So I'd ask the court to indulge us again for another pretrial setting, again, sufficiently far out to allow the court to entertain if this is an appropriate expert, what her role will be in the case, and then to allow the state to investigate whether LEO in Dallas or at Parkland may have those videos or have retained those videos.
Okay, can you tell me on the videos in which it was disclosed that there may be additional videos from Parkland or DPD? Who is stating that, or?
Mr. Spriggs states it.
Mr. Spriggs states it to law enforcement that.
No, I'm
video?
sorry. No, Judge, he is being recorded on a cell phone camera. These cell phone cameras or cell phones were turned over to the state. The state did a lot of diligence to locate them, image them, and produce the videos on those cameras, on those cell phone cameras to us. And it is in one of the 9 videos. They are all recordings of Mr. Spriggs speaking into the camera. I don't remember which specific video it is, but he states and discloses in the video that he was recorded by a Dallas law enforcement officer. I don't know if that's sheriff or if that's DPD or if it's just a Parkland, some peace officer assigned to Parkland. So I think it's one of those 3 agencies. Mr. Spriggs lived in South Dallas, but within the Dallas County Sheriff's Office jurisdiction. I don't know if that would have been the responding department or the Dallas Police Department was the responding department. My guess is it's one of those two. But he has a recollection and states that in one of those cell phone camera videos.
Mr. Hernandez.
Your Honor, I just wanted to add that in light of the fact that it sounds like Mr. Ashmore actually has a better idea of what he's looking for. He has the power of subpoena as well, Your Honor, and based on conversations with his client, based on that video that has been produced, we certainly haven't made any attempts because it's just such a vague request to reach out to 3 agencies of that size for a video that may or may not exist. I think he may be able to drill down with his client and make a much more specific request as to dates, times when potentially these videos were shot. So I just don't believe that that's something that we really have the capacity to do, and it's just shooting in the dark from our angle.
Wasn't Mr. Spriggs, though, arrested initially in Dallas County and then transferred to our custody?
At Parkland. So we know it's that, what, maybe 5 days before he was brought here? So we gotta.
And your client does not know which agency he believes has a video of him?
May I have a moment to
Yes, please.
confirm with him?
Yes.
Mr. Spriggs recalls that it was that the responding law enforcement agency was Dallas Police.
Dallas Police Department.
Is there a date that might be associated with that contact?
May I get my laptop, Your Honor?
Yes.
So week of July. '25 through 1st of August. This is as narrow as I can make that request. There was a warrant issued out of Canton, Van Zandt County on 1 August 2021. And as I understand the facts, he was picked up at Parkland. So that video would have been made sometime between 25 July and 1 August 2021.
All right, what do you anticipate to occur at the evidentiary hearing, Mr. Ashmore?
Well, we have our motion to suppress the statement Mr. Spriggs gave on August 1st or 2nd, 2021. I don't, off the top of my head, just a moment, Judge, I don't believe the state has filed any other pretrial motions as of yet. I think that's our only contested pretrial issue is the suppression.
Okay. So
That's been on file for over a year. And or about a year, maybe not quite, close to June.
yeah, I know the majority of our time has been spent waiting on a cell phone dump. So
Yeah,
we've been riding the docket, waiting for that to be done. And so the only evidentiary matter left now is what you've raised today is a potential audio video statement by your client to state agency. So this is what I'm gonna do. We're gonna set Mr. Spriggs, because we're coming up on the 3rd anniversary of his arrest for this offense. So we're gonna set Mr. Spriggs for a motion to suppress hearing on May 30th. Between now and then, I would order the state to contact the Dallas Sheriff's Office, the Dallas Police Department, and Parkland Law Enforcement, and ask each one of those agencies if they have any reports or audio video recordings, any information concerning Casey Lynn Spriggs for that time period of July 25th. Let's just say July 25th, 2021 through August 1st, 2020. If the state does discover additional evidence, and if that evidence is then susceptible or arguably susceptible to a motion to suppress or other issue, then I'll consider continuing the suppression hearing to another date to allow defense time to review that. In between now and then, Mr. Ashmore, I will communicate with you ex parte regarding your ex parte request.
yes, Judge. And that date is set on my calendar for the motion to suppress. Is that a 1:30 at the
1:30.
at the courthouse?
Yes, sir. 1:30 at the courthouse.
Okay. Thank you, Your Honor.
All right, and Mr. Hernandez, if the state does find that information, we need to get that to Mr. Ashmore as soon as practicable so that should he need to file a contested motion that could be heard on the 30th, that he's able to do so.
Will do so, Your Honor. Thank you.
You're welcome.
Thanks, Judge. Thank you, Mr. Hernandez.
All right, Mr. Spriggs, we'll see you back on May 30th.
Thank you.
You're welcome.
May I be excused, Your Honor?
Yes, thank you, Judge.
Thank you. Thank you, Mr. Hernandez.
Ms. Taberham,
Yes, Your Honor.
do you expect someone to be zooming in? An attorney to be zooming in?
Yes, that Bruce Lambert's gonna make a on,
Joshua Davis?
yes, the one that's in federal custody.
Okay, I see a cell phone in the Zoom waiting room. Just wanted to make sure. Who are you ready on, Mr. Smith?
Marshall Parker. Hold on.
All right, this is cause number CR 23-31, State versus Marshall Deshaun Parker, motion for bail reduction and pretrial. Go ahead on the pretrial first, Mr. Smith.
On the pretrial, Judge, at this point in time, we don't have any contested motions that the court needs to hear. Would ask the docket call setting be next.
All right, the court will set Mr. Parker for docket call hearing on May 28th at 1:30. And on the motion for bail reduction, do you want to call your client?
Do Joe.
All right, Mr. Parker, you're going to be called for purposes of your motion for bail reduction.
Yes, sir.
So I'm going to have, once you get through signing there, I'm going to have you raise your right hand so I can place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
All right, thank you, sir. Just continue speaking up loudly and clearly like you have been. Go ahead, Mr.
Yes,
Short.
sir. Thank you. Mr. Parker, you're currently incarcerated in Van Zandt County Jail on this particular cause, is that correct? Yes, sir. And your bond is set at $50,000? Yes, sir. And at this point in time, are you able to make a $50,000 bond? No, sir. Now, you have made attempts to post bond in this case, with the aid of your wife, as well as contacting bondsmen. Have those, efforts been successful? No, sir. Now, you're asking for a bond reduction. Is there an amount of bond that you believe you could post if the court were to grant you a reduction? 10,000, 20,000. So basically you're asking the court to grant you a between $10,000 and $20,000 bond. Yes, sir. Okay, and if the court did reduce that, you would likely be able to make that bond. Yes, sir. They're all bonds, but. Yes, sir. Now, if you were to post bond and the judge were to grant your request, where would you be living? In Marshall, Texas. Don't get that. You can get the address. 2308 Scotts Quarter Road, Marshall, Texas, 75670. Marshall is about an hour and a half drive from here, is that right? Yes, sir. Do you have the ability to get back and forth to court? Yes, sir. You have reliable transportation, et cetera? Yes, sir. And in addition to that, would you warrant to the court that you would make any and all court dates that he sets for you? Yes, sir. You understand you also have conditions of pretrial release that would require you to report and follow other restrictions. Are you aware of those? Yes, sir. And are you able and willing to follow those while on bond? Yes, sir. Now, ultimately, you've been in custody for how long? Do you know how many days? Since July of last year, about 200 some days. About 200 and some days. And you were found indigent by this court in appointed representation, is that correct? Yes, sir. Were you able or did you attempt to hire your own lawyer? No, sir. And did you have the ability to hire a lawyer? No, sir. So just like that, in your bond, you don't have the funds to hire a lawyer, but you may be able to make some bond if the court would grant you a reduction. Yes, sir. And you're asking the court to reduce your bond to $10,000, is that correct? Yes, sir. Cash or surety? Yes, sir. Pass the witness.
State your witness.
Mr. Parker, going back to 2013, do you have a recollection of being convicted of credit card or debit card abuse?
Yes, sir.
Okay, and you were actually granted probation on that case, isn't that correct?
Yes, sir.
And your probation was revoked, was it not?
Yes, sir.
You did not comply with the conditions and you had your revocation provoked and you actually served some time for that, did you not?
Yes, sir.
And subsequently in 2014, you were also convicted of escape while arrested, confined, a third-degree felony. Isn't that correct?
Yes, sir.
If you were to be granted a lower bond, sir, where would you be working?
With my brother-in-law at General Cable. So,
manufacturing company for cable wire.
Okay. So it's a private business, or does he work there as well?
He works there as well.
Okay. So it's not his business, personal
No,
business.
no, sir.
Okay. You also were convicted in the same year, 2014, of burglary of a building, a state jail felony, and served 24 months. Isn't that correct?
Yes, sir.
Okay. And was that as a result of failing on probation conditions as well, sir?
Yes, sir.
And as late as 2021, you were again convicted of credit card or debit card abuse. Isn't that true? A state jail felony.
Yes, it was old from 2015, but I didn't get a chance to get in the court to it till I discharged my prison sentence, and they gave me time served.
And you served 12 months for that conviction
Yes,
as
sir.
well.
Yes, sir.
I have nothing further, Your Honor. I pass the witness.
Anything further, Mr. Schmidt?
Yes, sir. Mr. Parker, so ultimately, the answer to your questions pertaining to your past, all of those prior convictions, how old were you in 2014?
18.
So that's been quite a bit of time ago. Is that correct?
Yes, sir.
Now, from the time that the last one happened, I guess it was 2021, you're telling the court that that case had been pending since 2015, is that correct?
The charge was for 2013, but they put the hold on me in 2015, so they gave me all that back time up until 2021.
So even though the paperwork reflects 2021, that's not accurate, is that correct?
No, sir.
So basically from 2014 and a half, maybe 2015, you've been working, been taking care of your business, taking care of your family, and you haven't really gotten into trouble.
Yes, sir.
How old are you now?
28.
So you're 28, and most of this stuff happened when you were just barely an adult, 17,
17, 18, yes, sir.
Okay. And at this point in time, do you have any children?
Yes, sir. I have 5 sons.
So you got 5 sons at home that you need to go home and take care of?
Yes, sir.
And you understand that, you're charged with a third-degree felony here, but we intend to fight that charge, obviously, correct?
Yes, sir.
And you'd like to be out at liberty supporting your family while this case is pending, is that correct?
Yes, sir.
Pass the witness.
Mr. Hernandez, anything further?
Let's see, Your Honor, just a quick moment here.
While you're looking, Mr. Hernandez, I do have a few questions myself.
Okay.
Mr. Schmidt, were you aware that Mr. Parker's original bail was $10,000?
No, sir.
Were you aware that Mr. Parker failed to appear in court here on April 25th of 2023?
I may have been aware of that.
And were you aware that the court took it under advisement to allow Mr. Parker to provide medical documentation as for his absence? And were you further aware that the medical clinic that he provided documentation to verified that they did not see Mr. Parker on that date, nor did the person who allegedly signed his medical documentation that she didn't work there anymore, and that that's not one of their forms. And that's how Mr. Parker ended up in jail on a $50,000 bond instead of a $10,000 surety bond that he had already posted. I didn't know if you were aware of that. You were appointed after the fact in January of 24 or something.
I'm not sure if I'm aware of that. And I'm not sure that I would have thought to ask that question to you. So.
And the state would have no additional questions, Your Honor. Thank you.
Do you want to discuss any of those issues with your client for any follow-up questions, Mr. Schmidt?
Briefly.
Go ahead. Go ahead, Mr. Schmidt.
We have no further questions, Judge.
All right, anything further from the state?
No, Your Honor, thank you.
Any argument, Mr. Schmidt?
No, sir.
Any argument from the state?
No, Your Honor.
All right, court is going to deny Mr. Parker's request for a bail reduction in this matter, and bail will remain at $50,000.
Thank you.
We'll see you back on May 28th. Who's next, Mr. Schmidt?
Got Jason Williams in here.
Jason Rashad Williams, CR 23-248-249, 250-251. Believe that we're set on pretrial, all those matters.
That is
Good.
correct.
Go ahead, Mr. Schmidt.
As of today, we have not filed any contested pretrial motions. I don't anticipate needing any. However, we would ask the court leave to file late pretrial motions if they should become necessary assuming the state has no objection to that, and set this matter for a docket call.
Any objections to the defense request to file motions late if needed?
I guess not, Your Honor. If that's the practice, I guess acknowledging the fact that we may need some time to prepare depending on the text of the motion.
And I'm certain that we will have conversed with the state prior to any of that becoming necessary. Ongoing communications.
All right, court will find that there are no contested pretrial motions filed. Court will allow defense to file a late motion after ample notice to the state and before setting them for a hearing. Court sets Mr. Williams for a docket call. Do you want that May 28th date, Mr. Schmidt?
You say May 28th, Judge?
Yes, sir. Do you want that date?
That's fine.
All right, court sets Mr. Williams for docket call on May 28th in each case.
Okay, you're good. Mr. Morgan. I'm very sensitive about my efficiency.
All right, you said this is Mr. Harold Morgan?
That's correct, Judge.
All right, this is written number WR 24-17. Mr. Harold James Morgan Jr. Is this a writ seeking bail reduction?
It is a 17-151 delay writ seeking a personal recognizance bond for Mr. Morgan. He was arrested on January 3rd, 2024. Remains unindicted, unfiled. If the court would like testimony pertaining to his ability to make bail at a reduced amount, I can call him for that purpose.
Yes, sir, please. Mr. Morgan, if you'll raise your right hand. I'm going to place you under oath, sir. Do you swear that the testimony you give to the court today will be the truth, whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, thank you. Put your hand down. Make sure you speak up loudly and clearly. Go ahead, Mr. Schmidt.
Mr. Morgan, you've been in custody of Van County Jail for greater than 90 days, is that correct? Yes, sir. And you have not been indicted on the charges that you were arrested for, is that correct? Yes, sir. Now, prior to coming here today, your bond has been set at $350,000, correct? Yes, sir. And are you able to post $350,000 for the bonds? No, sir. Now, you have filed an affidavit of intimacy, listing all your assets, requesting a court appointed attorney, is that correct?
Yes, sir.
Is that affidavit remain true and correct as far as your property and your assets?
Yes, sir.
And ultimately, if the judge were to reduce the bond, would you have any assets at that point to post bond?
No, sir.
So you have no ability to come up with any financial resources to post any amount of cash or surety bond, is that correct?
Yes, sir.
Are you asking the court to grant you a personal recognizance bond while this matter is pending?
Yes, sir.
Pass the witness.
Mr. Hernandez,
Thank you, Your Honor. Mr. Morgan, where would you reside if you were to be granted a PR bond?
With my mother in Kaufman County.
Are there any minors currently living with her, sir?
No.
And according to your petition of indigency, you will own no property, sir. Is that correct?
Yes, sir. I don't own anything.
You don't own anything.
No, sir.
No automobiles,
No, sir.
no financial accounts of any type.
No, sir.
Who owns the home where your mother lives, sir?
My mother and my stepfather.
You have any other siblings, sir?
I'm going to object to relevance, Judge.
what's the relevance, Mr. Hernandez?
You know, there's been a statement that there is no way he could come up with any money for the bond, and I'm just seeking to see if, in fact, he can come up with some money to make a bond that may be reasonable under the circumstances.
Well,
Family
Judge,
is always the first place where you reach out to, Your Honor.
And Judge, the defendant's family's assets are really irrelevant when it pertains to determining whether or not an individual is indigent or capable of making a cash or surety bond. Ultimately, most people seek help from their family members in order to make a cash or surety bond, but they're by no means required to do so, nor could their assets be taken into account when determining what is a fair and reasonable bond. Under the circumstances, I would say that it's not relevant because Mr. Morgan has been in custody greater than 90 days and has not been indicted. He's testified that he has no assets. So by statute, I believe that there's only one course. I mean, obviously, if he could make some bond, you could do a reduction by law, but he's testified that he can't do that. So to continue with the questioning about his family or extended family members is irrelevant.
All right, court will sustain the objection.
Pass the witness. I have nothing further, Your Honor.
No
Anything
further
further, Mr.
questions,
Schmidt?
Judge.
Is Mr. Morgan, are you married?
No, sir. I just recently got a divorce.
Okay, and in the divorce, did you receive any community property?
No, sir. She took it all.
She took it all, or you gave it all, or what?
Kind of a little bit of both.
A little bit of both?
Yeah,
So once before, you did have assets, you did have a
when I was
home,
married. When I was married, yes.
and how recent was that?
My divorce was finalized, March 5th.
All right, so 2 weeks ago, less than 2 weeks ago.
March.
Oh, I'm sorry, about a month ago.
Little over a month.
Okay. All right, then, based on the evidence presented to the court finds that Mr. Morgan has been in custody continuously for more than 90 days. The state has not returned an indictment pursuant to 17-151. The defendant is therefore entitled to be released on a personal bond, personal recognizance bond, or a reduced bail that he can make. Court finds that based on the evidence, Mr. Morgan does not have any assets or ability to post any type of bond. The court therefore finds that he's entitled to be released on a personal bond in the amount of $150,000 for the sexual abuse of a child under 14 and $200,000 personal bond on sexual assault. I've signed those, Mr. Schmidt, and we'll forward those over to the jail.
Thank you, sir.
Thank you, sir.
Mr. Admire.
And Mr. Schmidt, tell Mr. Morgan to make sure that he signs the conditions of pretrial release before he's released from custody.
Yes, sir. We don't need to ask that. That's not.
They haven't signed.
The judge has already signed. They're here, Judge. He'll be signing them briefly.
Excellent, Brett. And I think Mr. Holmes, he was your client also, right?
It was indeed.
Yeah, he'll need to sign his as well. All right, who do you have with you now?
This is Daniel Jack Admire.
All right, this is writ WR 24-8. Same position, Mr. Schmidt, 17-151.
Yes, sir.
All right, and do you want to call him for his ability to make any kind of reduced bill?
I will, Judge. I would note for the record, as I'm reviewing my writ, that there's a Scribner's error on his date of arrest. I have 12/14. It was actually December 6th. 2023 is the date that this jail shows him admitted to custody.
All right, Mr. Admire, if you'll raise your right hand, I'm gonna place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand. Make sure you speak up loudly and clearly. Go ahead, Mr. Smith.
All right. Mr. Admire, you've been in custody since December of 2023. Is that correct? Yes. You remain unindicted on this charge? Yes. Your bond is currently set at $150,000 cash or surety. Are you able to make that bond? No. Now, obviously, you've heard the court state that under 17-151 for delay, that you're entitled to a PR bond or a bond reduction in which you can actually post. So the questions I have for you pertain to your ability to post any kind of cash or surety bond. Do you understand that? Yes. So do you have, well, let me ask you this. You filled out an application for court-appointed attorney with an affidavit of indigency, is that correct? Yes. And is everything on that affidavit true and correct? Yes. And does it remain true and correct and unchanged today? Yes. So as far as that affidavit is concerned, you still remain indigent? Yes. Now, do you have any assets that you're aware of, bank accounts, cars, property that you could sell or trade or put as a guarantee for a cash or surety bond? I have a 32-year-old travel trailer. Okay, and is that where you normally reside in your travel trailer? So that would be your home. Do you have access to that as of today? In other words, you don't have it in the parking lot of the jail, right? No. And if you did, you wouldn't be able to actually use that as surety for a bond. Correct. Now you have a father, I think, are you in contact with him? In other words, let me ask you this, is there any family member that is willing and able to help you post a reduced bond? No. And other than your travel trailer, which is 32 years old where you live, you have no other assets? Correct. Are you asking the judge to grant you a personal reconnaissance bond while this matter is pending? Yes. Pass the.
Mr. Hernandez.
Thank you, Your Honor. Sir, would you be employed if you were released on a reduced bond or a personal recognizance bond?
I would have to find employment.
And where would you be living, sir?
I would be living in Allen at a friend's house.
Okay, so you wouldn't be living in the trailer that you currently own?
I don't know that I have a functional relationship with the people whose land it's on at this point. The discharge has kind of.
And where would you be living, sir? What town? Allen. Okay, and would you have transportation to make your court appearances as well as any check-ins with probation, sir?
Yes.
What did you do for work prior to this this arrest?
Construction.
I have no further questions, Your Honor. Thank you.
Mr. Admire, how are you going to travel from Allen to Canton for your court dates? How are you going to do that?
A friend who will be letting me live at her house. apartment.
Okay, so she'll be driving you back and forth?
Yes.
And when you have to be here at 9 o'clock in the morning, she's gonna be able to leave at 7 o'clock or earlier to get you here at 9 o'clock and drive back?
Yes.
She doesn't work or have kids that she has to care for, or anything of that nature?
She works, but with the flexible schedule.
Mr. Schmidt, anything further?
No further.
Mr. Hernandez, anything further?
No, Your Honor, thank you.
All right, court finds that Mr. Daniel Jack Admire has been continuously confined for more than 90 days, that the state has not returned an indictment in this case, therefore that Mr. Admire is entitled to be released on a personal bond in the amount of $150,000. The court has also signed conditions of pretrial release that Mr. Admire not have any communication with the alleged victim in this case, and not to communicate in any manner directly or indirectly with the family members of the alleged victim, in addition to several other conditions of pretrial release that Mr. Admire must sign before he is released from Van Zandt County custody. All right, we're adjourned in this hearing.
Thank you, Judge.
Either they'll come out there with the PR. Your Honor, I believe we are finished except for the one that you have on Zoom.
Okay, that's everybody. That's all there is. Let's see. What about Timothy Lane Simpson? I see that he's in the Coffin County Jail, but we should at least call that and reset it with Mr. Schmidt. I don't know if
He was one of the ones that the bench warrant was not executed.
Okay, so I want more information on that. So what was the issue again? Tell me.
You signed the bench warrants on Friday.
And he's in Kaufman County custody, and the bench warrants were returned by who?
The jail,
Which jail? Kaufman County or Van Zandt County?
Van Zandt,
Okay, and Van Zandt County Jail returned it. Why?
saying that they were in our custody.
Okay, then go get them and bring them up here.
Go get what?
Go get whoever's in our custody. Go get them and bring them up
Well, I'd like to, but they're not in our custody.
here. Okay, whose custody are they in?
Kaufman and Smith.
Okay, they're there because we've housed them over there.
No,
Okay, so I'm confused. So you're telling me that there's an inmate that we need that's in another county that's not in our custody, that I've done a bench warrant, and the jail has returned it because they're saying that that person is either A, in our custody in that jail, and you're telling me that's not the case, or B, that they were being housed in Kaufman County or Smith County or wherever else on our hold, but that's not the case either.
yes,
right?
Your Honor, that is the way I understood. I can go ask Lieutenant Salva to come here and.
Yeah, let's do that, because I'm confused as to why my bench warrants are not being executed.
Hang on just a second. Okay, Your Honor.
Yes, ma'am.
Okay, Lieutenant called Christy Broyles, who Carlos Banda brought the bench warrants out here to. Miss Broyles asked Carlos if they were in custody, and he said yes.
Well, they are in custody in other
I mean,
counties.
custody here. And he said yes. So she puts them in the black bag and sends them back to the courthouse.
And so did they not think to ask, why are you bringing bench warrants out for people who are already in our custody? Did they not think to ask that?
Christie normally doesn't take the bench warrant, that's normally Sherry and Sheila.
She said that usually Christy does not take the bench warrants. It's usually Miss Bellamy and.
Sherry, Harvey?
But I called over and asked you to give them to her. And they
So what do I need to do? What's the proper procedure for us to make sure that when we send a bench warrant over, that it goes to the right person who knows to get them lined up so we can go pick these people up in other counties so we can bring them back and do the, if we're taking them to the wrong person, then we need to know. If we need to take it to, we need to CC 2 or 3 people, we need to know. But I'm not in the habit of sending bench warrants over for people already in our custody. That's a waste of my time.
So who do we need to give them to?
Sherry or Sheila.
The ladies at the front window. All right, I will make sure in the future that we have a sticky note and that they go to Miss Bellamy or Miss Murphy.
I mean, the bench warrants say on them where they're at. It tells them they're in Kaufman
Tells
County.
you that they're in Kaufman County.
So a simple reading of it tells them that they're not in our custody, or if they have a question, they can look at the bench warrant and they can look in their system. And if the name pops up in Van Zandt County, you say, oh, hey, well, we don't need a bench warrant. We have them here. We can confirm it. Otherwise, let's don't assume that they're here and let's go get them in other counties.
Yes, sir.
Okay. And so did you get my message that whoever was in the waiting room is not there anymore?
Okay, that was Mr. Lambert, because he had emailed me to see what the Zoom link was, and so I sent it to him an hour or so ago.
Okay, he's not there, so let me see if Alfredo's still here. Alfredo, you still there?
Yes, sir, I am.
All right. Do you know anything about Mr. Lambert's client, Mr. Davis, that's in federal custody? I think we were just getting a status update. I was hoping to get some kind of definitive answer on what we're doing with Joshua Davis.
And to date, I have not been given an update on that case, Your Honor.
Do you know if your office intends to continue prosecution if the feds have him? Because this has been since, I think y'all filed in November of 22. So we're at a year and a half, and I don't think we've ever had him in our custody.
Because we're gonna.
Let me take a quick look to see if there may be a note with a date closer in time to now.
Well, I'll tell you what, don't use your time up today. Let's do this. Let's reset him, but I'm going to ask the state. I can't ever get any information out of Mr. Lambert or anybody else that shows up. So can I ask the state to reach out to the federal prosecutors to get a definitive, either they're prosecuting him for this crime and you are going to dismiss, or he's going to go up for sentencing at a certain time, and we know when we can either request a bench warrant or a 1245 or something. Can I ask your office to do that? Because I just
Absolutely, Your Honor. Yeah, I will.
Just don't trust I'm going to get it otherwise.
Nope, I will see to it. We will follow up on that.
All right, let's reset this for May 28th. We'll just do another status of federal custody. All right, Ms. Abraham, was that? All right, so all these guys that did not get picked up on a bench warrant, do you want me to set them again, or do we want to wait till we get them in custody and then set them?
Well, Mr. Smith had asked me to bench warrant them.
So we can go ahead and set them on 5/28. We can, so that would be Robert Maynard Hodgson, CR 24, 22, and 23. He's in Smith County. Let's just set those for 5/28. Cause I'm not sure if we do it any sooner. If Mr. Schmidt's gonna be available, the other days are Thursdays, so. Since we didn't get them today, it's gonna set us out over a month. So let's just do that in each one of those cases, for arraignment, 5/28. Hodgson and,
Simpson.
Timothy Simpson. 5/28 from Kaufman County. There was another one too, wasn't there? There's 3 we marked off the docket, right?
Well, the other one was Miss Dovey, and that was,
Oh, Ms. Dovey, okay,
yes.
that's the one this morning with Mr. White, okay. All right, let's set those other 2, let's get new bench warrants, and for Kaufman and for Smith, and we'll set those 5/28, we can let Mr. Schmidt know.
We will
All
see you
right, I
momentarily.
believe that is a wrap, appreciate y'all, court's adjourned.
Thank you.